Director, my lord.
Mr. Stanley Atude, your designation.
Deputy Director, my lord.
Deputy Director.
Yes, civil
Deputy
litigation.
Director what? Civil litigation.
Civil litigation, my lord.
Kogi Ministry of Justice.
Minister of Justice.
With
me is G.O. Sani.
G.O. Sani, where is Sani?
G.O. Sani.
Yeah, my lord.
It's on.
Okay. For who?
For the defendants, my lord.
Are you for the defendants?
Yeah, for the defendants, my lord.
Very well. Here is the judgment of the court. It is the case of the claimants that they were all former members of the second defendant representing Omale, Yagba West, Koto-Karfi, and Ogori Magongo state constituencies in the Sixth Assembly. They have heard that it is customary and in line with the parliamentary practice of the second defendant to raise a budget for every successive assembly year wherein provisions are made constituency allowance for members, and that in their third year of the Sixth Assembly in 2018, they were entitled to the sum of 20 million naira each, while in their fourth year in 2019, they were entitled to half of the constituency allowance of 30 million naira for the year in the sum of 15 million naira, which was duly appropriated for in the assembly budget. They continued that while all members of the Sixth Assembly were paid for 2018 legislative years, except the claimants, with the promise that they will be paid in due course, citing fundamental omission. They further averred that based on the promise made by the first defendant, they initiated constituency projects using known contractors, which were mobilized to their respective sites of the projects in the claimants' constituencies without any cash backing. They stated that such projects reached an advanced stages, but was abandoned due to lack of funds. They continued that the fourth defendant has been served with a demand notice for the balance sum by the contractor, threatening legal action, while for other claimants, the contractors have been making oral demands. They averred that on the 24th of July 2019, the sum of 750 million naira was paid into the account of the second defendant for the purpose of 2019 constituency allowance, from which members of the Sixth Assembly who will not return to the Seventh Assembly are by law entitled to half of the sum, being 15 million naira for the half of the year, but they were never paid. They further stated that they were denied their severance allowance of 4.3 million naira only upon the expiration of their tenure in 2019. They continue that they have been discriminated on ground of their peculiar political interest, even though some of them belong to the same political parties as the first defendant. It is against this backdrop that claimants initiated this action by a general form of complaint dated 8 June 2022, praying for the following reliefs. 1, a declaration that claimants are entitled to their constituency allowances for the legislative year 2018 and half of the legislative year 2019 as appropriated for, and same having been paid to other colleagues. 2, a declaration that the refusal and or neglect of the defendants to pay to the claimants their constituency allowances for year 2018 and half of the year 2019 as appropriated for, while other colleagues were paid, same is discriminatory, unlawful, illegal, and antithetical to the parliamentary practice world over Kogi State inclusive. 3, an order of the Honorable Court awarding the sum of 120 million naira for each claimant as their constituency allowances for the year 2018 as appropriated for. 4, an order of this Honorable Court awarding the sum of 90 million naira to the claimants representing the sum of 15 million naira only for each claimant as their constituency allowances for half of the year 2019 as appropriated for. 5, an order directing the defendant to pay to the claimants the sum of 25,800,000 naira to the claimant representing the sum of 4.3 million naira only each as their severance allowance of the deceased assembly. And 6, another court awarding general damages of the sum of 2.5 million naira each to the claimants. In response to the claimants' pleadings, the defendants filed their statement of defense where they averred that no contract was awarded in anticipation of funding, but upon the availability of funds in successive legislative year wherein projects were executed. They stated further that the claimants cannot lay claim to the sum of money due to the fact that what was contained in the budget was constituency projects and not personal allowance as such. The monies, if available, goes to the current members of the House to enable them carry out the projects. They maintained that the money released then did not go around as result that they paid in batches, which was the reason the claimants could not access the funds. They noted that though constituency representatives receive the allowances on behalf of their constituents, as the constituency allowance are usually paid into the personal accounts of the House members, but it is not personal allowances. They contended that they never made any promise to the claimants at any time, and their alleged projects were never carried out based on any promise. They continue that the alleged project was personally awarded by the fourth claimant, and that the alleged company awarded the contract is unknown to law as the letter of award was not pleaded. Hence, the said contractor cannot enter into a valid contract with the defendant as there is no such project awarded officially for the constituency. He also stated that if there was any omission in respect of payment of the averred that the alleged project was personally awarded by the fourth claimant and that the alleged company awarded the contract is unknown to law as the letter of award was not pleaded. Hence, the said contractor cannot enter into a valid contract with the defendant as there is no such project awarded officially for the constituency. They also averred that if there was any omission in respect of payment of constituency allowance, such shall not be paid to persons who are no longer members, but shall be disbursed to the current occupier as projects validly or legitimately instituted shall be borne or paid for by the successive occupier of the constituency seat. After the close of pleadings, parties on the 24th of January 2023 intimated the court of their voluntary consent to adopt the argument on record procedure, which is pursuant to the 38 with 33 of the NIC and Civil Procedure Rules 2017, and was graciously granted. The effect of this procedure is that this case is to be argued on record based on the pleadings, witness statement, and documents concluded by parties, dispensing with the need for cross-examination. Pursuant to this procedure, the court asked parties to file their respective final written addresses. As it is customary to do in this special procedure, and in accordance with the rules, claimants file their final written addresses first, and I've reduced that into the body of the judgment. Counsel on behalf of the defendants equally filed theirs on 15th of March 2023. I've reduced that into the body of this judgment, and then the claimant filed the reply on point of law as well. I've reduced all that into the body of this judgment. I will now go straight to the decision of the court. Having given the case at hand an in-depth consideration upon the perusal of the originating processes, the statement of defense of the defendants and final written address of parties, the court is of the view that the issue that will be determined, the issue that will best determine this action is whether or not claimants have proven their case to be entitled to the relief sought. In our jurisprudence, the burden of proving the suit lies on the person who will fail if no evidence at all were given on either side. See Section 132 of the Evidence Act 2011, which is hereafter the Evidence Act provides us, and I quote, In civil cases, the burden of first proving existence or non-existence of the fact lies on that party against whom the judgment of the court will be given if no evidence were produced on either side, regard being held to any presumption that may arise from the pleadings on court. Quite apart, this action is no doubt a declaratory one, as seen from the release. The position of the law has remained unchanged, that claimants in a declaratory action must prove his entitlement to relief sought. To this end, he must rely on the strength of his own case and not on the weakness of the defendant's case. See the case of Mohammed versus Wamako and other citation captured, AG Cross River State and AG Federation citation provided, Anyaru and Mandila's limited citation also provided. However, nothing precludes such claimants from relying on aspects of defendant's case that support his own. The burden of proof on claimants in establishing his entitlement to the declaratory reliefs sought to the satisfaction of the court is quite heavy, in the sense that such declaratory reliefs are not granted even on admission by the defendant, where the plaintiff fails to establish his entitlement to the declaration by his own evidence. See the case of AG Cross River State and AG Federation and another citation captured, Dumes Nigeria Limited and Nwakoba citation also provided. As such, claimants in this case are expected to rely on the strength of their own case in proving their entitlement to the relief sought. Claimants by paragraph 1 of the dissenting Omala, Yagba West, Mokwamuro, Kogip, Kotonkarfi, Bassa, and Ogorimagongo of Kogi State constituencies and the second defendant. The defendants in response by paragraph 1 of their joint statement averred that they deny paragraph 1 as their facts within the claimant's knowledge. I do not think this is a sufficient traverse of paragraph 1 in the statement of facts, and which will be deemed an admission. Reason being that the facts averred in paragraph 1 of the claimant's statement of facts as regards their former membership of the second defendant cannot be said to be facts within the knowledge of the claimants alone. If the claimants were former members of the second defendant or not, then the defendants will know. As such, they are expected to frankly deny or boldly admit that fact. What is more, the court is entitled to consider the whole statement of defense and not just each paragraph alone, as is the case generally with pleadings, in order to ascertain the issues so joined. Thus, a statement of defense has to be read harmoniously, considering all the paragraphs together in order to know its tenor and ascertain the issues properly so joined. See the case of Adama and Kogi State House of Assembly citation captured, Salini Nigeria Limited and Lifewire Industries Limited and another citation provided, Arison's Trading and Engineering Company Limited and Military Governor of the State citation captured. Defendants who have averred in paragraph 1 of their joint statement of defense that facts of claimant's former membership of the second defendant are facts within claimant's knowledge alone, went ahead in paragraph 6 of the said statement of defense to assert that claimants are no longer members of the House at present. Having regard to other facts in the pleadings of the defendants, it is clear that the defendants, notwithstanding paragraph 1 of their statement of facts, have admitted that claimants are former members of the second defendant, that is the House of Assembly, Kogi State. It is a settled position of the law that facts admitted needs no further proof. See the case of Akaniwo and Inserim citation captured, Salawa and another, and Yusuf and another citation provided. Thus, it is not in dispute that claimants are former members of the Sixth Assembly and the second defendant. Claimants in this case are also seeking for the payment of the arrears of their constituency allowance as political office holders. The Constitution by Section 254C, subsection 1, paragraph K, 1999 Constitution as amended, gives the court jurisdiction over dispute arising from the entitlements, including allowances of political office holders. Specifically, it provides those, and I quote, paragraph K, relating to or connected with disputes arising from payment or non-payment of salaries, wages, pensions, gratuities, allowances, benefits, and any other entitlement of any employee, worker, political or public office holder, judicial officer, or any civil or public servant in any part of the federation or matters incidental thereto, unquote. In order for the court to be able to properly address the issue of whether or not claimants who are no longer members of the House of Assembly are entitled to arrears of constituency allowances which were not paid to them during their stay in the House. It is expedient for me to first consider the provisions of sections 91, 112, 113, and 117 of the Constitution and their compliance. The said provision will now captivate the attention of this court. I quote, Section 91. Subject to the provision of this Constitution, the House of Assembly of the State shall consist of 3 or 4 times the number of seats which that state has in the House of Representatives, divided in way to reflect as far as possible nearly equal population, provided that House of Assembly of the State shall consist of not less than 24 and not more than 40 members, unquote. Section 112, subject to the provision of sections 91 and 113 of this Constitution, the Independent National Electoral Commission shall divide every state in the Federation into such number of state constituencies as is equal to 3 or 4 times the number of federal constituencies within that state. Unquote. Section 113, the boundaries of each state constituency shall be such number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable. Section 117. 1, subject to provision of this Constitution, every state constituency established in accordance with the provisions of this, just a minute, of this part of this chapter shall return one member who shall be directly elected to a House of Assembly in such number as may be prescribed by an act of the National Assembly, unquote. By the provision of Section 91 of the Constitution captured above, a House of Assembly of the state must be made up of 3 or 4 times the number of seats which that state has in the House of Representatives. And the seat in the said House of Assembly is to be divided in a way to reflect as far as possible nearly equal population, while sections 112 and 113 of the same Constitution provides for the division of states into constituencies, which will be 3 or 4 times the number of federal constituencies within the state, which division must reflect as far as possible nearly equal population. Section 117, subsection 1 provides that each constituency shall return 1 member who shall be directly elected to the House of Assembly of the state. As reasoned supra, it is not in dispute in this case that claimants are all former members representing Omala, Yagba West, Mokpa, Amuro, Kogi, Koton-Kalfi, Bassa, and Uguri-Magongo, state constituency of Kogi State in the second defendant. Claimants in this case are claiming to be entitled to constituency allowances for the years 2018 and 2019, which were not paid to them. Defendants in response by their pleadings have categorically stated that what is contained in the budget is not a personal allowance of claimants, but money meant for projects in the constituency of every member, and the claimants cannot lay claim to it now that they are no longer members of the House. It is equally the position of the defendants that though constituency allowances are usually paid to the personal account of House members to execute projects for the benefit of the people, they also maintain further that since claimants are no longer members of the House, they are not the one entitled to receive the arrears, but the present members of the House. Claimant by paragraph 3 and 4 of their reply averred that constituency projects are appropriated to enable members execute their personal constituency projects. Also, claimants by paragraphs 13 to 17 of their reply averred that they were denied their constituency allowances because of political sentiments, and that there have not been precedents of payments of backlog of constituency allowance to past members as the need never arose. Parties in this case are adding that in the years under review, that is 2018 and 2019, constituency allowances were appropriated for, that is passed as part of the budget of the House of Assembly for the year. In fact, the defendant by paragraph 6 and 7 of their statement of defense gave claimant notice to produce the 2018 and 2019 appropriation law or budget. Claimant viewed their letters adopting their final written address forwarded to this court, certified true copies of the second defendant's budget for year 2018 and 2019. I perused the said document at pages 117 to 127 of the records, And it is clear that in the budget of the state in the year 2018 and 2019, respectively, constituency projects were appropriated for. The effect of that, in my view, is that in the years 2018 and 2019, the sums captured therein for constituency projects were to be charged upon the Consolidated Revenue Fund of Kogi State. I say so in view of the clear provisions of the Constitution as regards the Consolidated Revenue Funds of the state and monies to be charged therefore from. The Consolidated Revenue Fund of the state is an account into which funds raised or received by the state are paid into. Monies shall be withdrawn from this account to meet the expenditure that is charged upon the fund by the Constitution, or where the issue of those monies has been authorized by an appropriation law, supplementary appropriation law, or law passed in pursuance of Section 121 of the Constitution. See Section 120 of the Constitution. The approved budget of Kogi State as contained in those documents is well within monies authorized by an appropriation law as used in Section 120 of the Constitution. Section 120, subsection 3, paragraph A of the same Constitution provides further that, I quote, "No monies shall be withdrawn from any public fund of the state other than the Consolidated Revenue Fund of the state, unless the issue of those monies has been authorized by law of the House of Assembly of the state. For no monies shall be withdrawn from the Consolidated Revenue Fund of the state or any other public fund of the state except as prescribed by the House of Assembly." The effect of the above is that the money for payment of constituency allowance is to be taken from the Consolidated Revenue Fund of Kogi State, since same was captured in the state budget for those years, that is 2018 and 2019. Claimant has specifically read paragraph 11 of their statement of fact about giving specific check numbers drawn in the names of members for the second defendant's account. Number 01013322343 with Zenith Bank allegedly in the sum of 16 million naira each, which sum were paid to the named members of their constituency projects, while a balance of 4 million naira each was paid to each of those members as 2018 constituency allowance, and thus pleaded the statement of account of the second defendant for the month of March 2019 and gave the defendant notice to produce same. They also averred paragraph 12 of the paragraph 12 of the statement of facts that specific checks numbers were drawn from the second defendant's UBA PLC account number 100-175-1014 in the name of another member in the house of 16 million, and that cash sum of 4 million naira balance paid to the said member as 2018 constituency allowance, and gave the defendant notice to produce second defendant's appropriation law. In respect of the constituency allowance for the year 2019, claimants by paragraph 21 to 23 averred, by 21 to 23 of their statement of facts averred, that to satisfy constituency allowance of 30 million naira per member for the year 2019, the sum of 750 million naira was paid by the Kogi State government into the second defendant's Sterling Bank account number 0073524592, and pleaded a statement of account of the said Sterling Bank account while giving the defendants notice to produce, and that members of the 6th Assembly who are not returning to the 7th Assembly are by law and parliamentary practice entitled to half of the sum of 30 million naira each, which is 15 million naira, since their tenure expires in June 2019, being half of the legislative year. Defendants have stated that though money was released for the purpose of constituency allowance, obviously from the Consolidated Revenue Fund of Kogi State, it could not go round, and it was agreed amongst members to be paid in batches and not as a result of remission as asserted by claimants. The claimants in response read their reply averred that there was no such resolution to share the money released in batches amongst members, as same would negate the norm of the House, and that in line with parliamentary practice, available funds disbursed are shared amongst members equally. Claimants who would want this court to believe that the stated sums were paid to those named members and who specifically pleaded the specific members of the checks, the specific numbers of the checks and the account numbers of the second defendant from which the sums were drawn and paid to the named members have the burden to prove the fact averred. Claimants who have made specific averment that the sum of 750 million naira was paid into the named Sterling Bank account of the second defendant for the purpose of payment of 2019 constituency allowance, out of which they are entitled to half of the sum each by law and parliamentary practice, have the burden to prove the said assertions. The burden of proving a fact in the pleading lies on the party who asserts the positive, as I've stated earlier, and not on the one who denies by asserting the negative. See the case of Malay and others versus Mustafa, citation captured. The case of Uru Agbara versus Ufoma, citation captured. This is captured by the Mazim E qui affirma non E qui negat incumbit probatio, which means the burden of proof lies on one who alleges, not on him who denies. Claimants are the one asserting the positive and thus have the burden to prove the assertion. It is when claimants have successfully proven those facts averred that the burden then shifts to the defendant, and it oscillates like that till when all the issues in the pleadings have been dealt with. See section 1332 of the Evidence Act. I'm mindful of the fact that claimants gave the defendant notice to produce their statement of account with Zenith and UBA as stated supra. The implication of giving notice to produce the document is that if the party on whom the notice to produce the document fails to do so, the party who gave the notice will then be entitled to rely on secondary copies of the document which is at his disposal. It is clear from judicial authorities that a party served notice to produce is not obligated to produce it, and that failure to produce pursuant to a notice to produce cannot be resolved as withholding evidence under section 167, paragraph D of the Evidence Act. Rather, it only entitles the party serving to rely on the secondary copy in his possession or proceed with committal proceedings for failure to produce. The Apex Court in the case of Buhari and Obasanjo citation captured Ways GSC, now retired, held us, and I quote, at any rate, the proper procedure to be followed as a result of failure to produce the documents is for the party that needed the documents to adduce secondary evidence of them in accordance with section 97(1), 1A and 98 of the Evidence Act, or ask the court to compel the defaulter to produce the document by committal to prison, unquote. Megore JSC, CJN now retired at page 154, paragraph DE, in his concurring decision, had this to say, and I quote, in notice to produce procedure, it is supposed that the person asking for the document knows of the contents, perhaps has a copy of it. If the person to produce fails to produce it, the secondary evidence of it can be admitted in evidence, unquote. Ijiwumi GSC of blessed memory on his own part in his concurring judgment at page 236 stated, and I quote, the tribunal in my humble view correctly stated the law when it said that a party on whom notice to produce is served is under no obligation to produce the document named therein. Such notice plus the failure to produce the document named therein merely enables secondary evidence of the document to be given. It therefore cannot be correct that the provision of section 149D of the Evidence Act, that's the Evidence Act before the 2011 Act, can be brought in aid. That section does not relieve a plaintiff of the burden of producing the document or proving its contents, unquote. See also the case of UBA PLC and Lawal and another citation captured, Aracon Global Investment Limited and United Parcel Services Limited citation provided in Wiki and State, citation captured SPDC and another Pursue, citation captured. It is clearly pointless serving notice to produce if it needs to be stated that a party will serve notice to produce, but who fails to produce same cannot rely on the document which he failed to produce and has presumably denied its existence by failing to produce same. See the case of Main Street Bank Registrars Limited and Ukandu citation captured, Main Street Bank Registrars Limited and Abimbola citation provided, Shegwan Kayode and other citation captured. Since the claimants did not adduce secondary evidence of the said statement of accounts to satisfy the court that such accounts and transactions were carried out on the said account, section 167D of the Evidence Act cannot be invoked. After all, It was the claimants who assert the existence of the account and the said transactions and the burdens on them to prove same. Claimants who would want the court to believe that the said sums have been paid to all those named members and that they are only being discriminated against have the burden to prove their assertions which they have failed to prove. I bear in mind the submission of Learned Claimants Counsel in his final address that Constitution means against discrimination of any sort, and which point seems to be the fulcrum of the whole of his written address. Yes, the Constitution beats Section 42 thereof means against discrimination of any sort, and the discrimination complained about must emanate from a law in force in Nigeria or any executive or administrative action of the government. See the case of Agbakoba and AG Federation of and other supra, case of Lafia local government and executive government, national state and other supra. However, before the claimants can be said to have been discriminated against by the defendants through their administrative acts to invoke constitutional provisions, the fact of discrimination must first be given or proven. See the case of Edo and others versus the Speaker, Cross River State and other citation captured. Claimants who in this case read their reply specifically pleaded the contents of an alleged WhatsApp conversation with the Deputy Governor to support their assertion of political discrimination has failed to bring any printout of such conversation before the court. If the claimants want the court to make a finding that they were discriminated against, they must proceed to lay before the court all available evidence in that regard. Besides, the judicial powers vested in court do not entitle it to interfere in the internal affairs of the legislative house or houses, including the way they conduct their business or their affairs. See the case of Senate of National Assembly and Tony Momo citation captured. Also, the claimants who would want this court to believe that by law and parliamentary practice, they as members of the Sixth Assembly who did not return to the Seventh Assembly and whose tenure finishes in June 2019 are entitled to half of the constituency allowance of 30 million naira each, have failed to bring to the attention of this court such law or any document purporting to evince the parliamentary practice, which makes them so entitled. Claimants have failed to discharge the onus on them to prove their assertions above, and the burdens does not shift to the defendants to disprove same. I must say here that although paragraph 32D item N of part 1 to the 3rd schedule to the Constitution provides that the Revenue Mobilization and Fiscal Commission has the power to determine the remuneration payable to political office holders, including legislators. Claimants were legislators under the Constitution since section 318 of the Constitution recognizes the House of Assembly as a legislative house, the effect of which any remuneration, which is that any remuneration including allowances fixed by RAMFAC to be paid to legislators at their bona fide entitlements. However, I'm not aware of any recommendation made by the RAMAC, Revenue Fiscal Allocation and Finance Commission. Neither has the claimant placed any such recommendation made by the RAMAC that constituency allowance is paid of such allowance that qualifies as a personal emolument or entitlement of a legislator, like wages or salaries or other personal allowance. In fact, parties in this case in their pleadings are evident that the money is not part of a personal salary or emolument of a legislator, but one which is for the purpose of constituency projects, which in my view is to bring the dividends of government closer to the people at the grassroots. It is thus clear that though the allowance is paid to the legislators, they are not the beneficiaries of the said sum, but there are various constituencies which have been created pursuant to section 112 of the Constitution, and for which each House member is representing pursuant to section 1171 of the same Constitution. The allowance is no doubt for the benefit of the constituents and not a personal emolument or entitlement of a legislator. I do not lose sight of the submission of Learned Defense Counsel in trying to justify his position that the constituency allowance is not a personal emolument of legislators referred to the provision of the public service rules, which define allowance. In fact, claimant counsel in his reply also relied on the same provision of the public service rules to buttress his own position that the allowance and entitlements of claimants. The position that agitates the mind of this court at this stage, the question that agitates the mind of this court at this stage is whether the claimants are public officers in the first place. By virtue of Section 318, subsection 1 of the Constitution, public service of the state in any capacity, in respect of which the government of the state and of the government of the state and includes service as A, clerk or other staff of the House of Assembly, member of staff of the High Court, Sharia Court of Appeal, Customary Court of Appeal, or other courts established for a state by this Constitution and by law of the House of Assembly. C, member or staff of any commission or authority established for the state by this Constitution or by law of the House of Assembly. D, state or local government council. C, staff of local government council. Just a minute. Yes. Of any statutory corporation established by law of the House of Assembly, staff of any educational institution established or financed principally by the government of the state, and G, staff of any company or enterprise in which government of the state or its agency owns controlling shares or interest. The interpretation at Cap 123 Laws of Federation 2004 by Section 18.1 thereof interprets a public officer to mean a member of the public service of the Federation within the meaning of the Constitution of Federal Republic of Nigeria 99, or the public service of the state. In the case of Asogwa and Chukwu citation captured, Acholonu GSC of blessed memory had this to say, I quote, I've carefully read the definition of the public service of the state as stated in Section 318, subsection 1 of the Constitution. I've already set down to whom it refers. It therefore goes without saying that neither the Speaker nor the non-statutory officer described as majority leader, which term or office is unknown in our statutory law, nor any member of the House is a public officer for the purpose of Section 138, subsection 1 aforesaid. So Section 318 does not include any member of the House at all, unquote. In the same way, in the case of Commissioner for Local Government and Chieftaincy Affairs and another Onakade citation captured, the court Pedongba mentioned JCA, quote, by virtue of Section 318 of the Constitution, public service of the state means the service of the state. Section 3181 of the Constitution further provides for non-political offices in the government of the state. However, the governor of the state is not in the public service of the state within the meaning of Section 318.1 of the Constitution. Deputy governor, the speaker, and all other political office holders are also not in the public service of the state, unquote. I'm, however, aware that under the 5th schedule to the Constitution, the definition of public officers includes political office holders. In my respectful view, the definition is only for the purpose of dealing with the code of conduct for public officers. See the case of Dada and Adeyeye citation captured. Claimants being former legislators are not public officers within the context of the law for one to be considering the definition of allowance in the public service rules to construe their entitlements. Claimants in this case claim to have carried out some constituency projects on credit through some contractors, which projects have been abandoned midway while acting on the promise of the defendants, and as such are entitled to recoup same from the defendants. They front-loaded copies of some documents through which they sought to prove this fact. Specifically by paragraph 14 of the statement of facts, claimant pleaded and front-loaded pictures of some alleged constituency projects carried out by some of the claimants. According to paragraph 16 and 17 of the claimant's statement of facts, some of the contractors they awarded contracts of constituency projects to have been orally demanding for the sum, but the contractor hired by the fourth claimant has made a written demand. Written demand letter was pleaded and is herein at pages 39 to 45 of the record of court. Defendants via their statement of defense have contended that claimants never carried out any such projects, and that if there was ever such projects, all claimants need to do is to liaise with the present members representing their constituency to see how the abandoned projects can be completed. First, let me address the submission of Learned Defense Counsel in paragraph 4.10 of the final address as to the admissibility of pictures front-loaded because the pictures are computer-generated evidence which must comply with the provision of Section 84 of the Evidence Act. The question of admissibility does not arise in this instance because the case at hand was tried on record, dispensing with the need to call oral evidence. To put it more clearly, the question of admissibility as contained in Section 84 of the Evidence Act as to admissibility of computer-generated evidence will only arise during our oral hearing when the document is to be admitted and not in this instance when the case is being tried on record with dispenses with oral hearing pursuant to the 38 and 33 of the Rules of Court. Learned Defense Counsel had consented to the argument on record procedure, which means that he wants the court to try the case on the strength of the pleadings and documents front-loaded, which presupposes that the documents front-loaded are okay, and he has no objection to that because before the court there was no such objection. The condition is Section 84 of the Evidence Act, which is to be satisfied in respect of computer-generated evidence, is for the purpose of admissibility of the document as evidence during hearing, which did not arise in this case. More so, by the provision of Order 15, Rule 3A and B of the Rules of this Court 2017, where a defendant respondent is served with a schedule of documents or any recording by an electronic device to be relied on at the trial by a claimant in compliance with Order 3, Rules 9 and 10 of the rules, the defendant shall file and serve along with the defense a schedule that indicates documents not objected to and schedule of documents objected to. Order 15, Rule 4 of the rules provided further that any document or recording by an electronic device contained in the schedule, which is not objected to by the defendant, shall be deemed admitted except the court otherwise directs. The defendants did not file any such schedule objecting to any document in this case. They are thus deemed to have admitted those documents and cannot at this stage be raising the question of admissibility of those documents, especially where the procedure adopted by consent of parties, in this case, special one. The point needs to be made that the law is settled that a party who has consented to a particular procedure adopted by court cannot later complain or say that it worked injustice against him. See the case of EcoBank Judicial citation, captured EcoBank and Siloam Global Services Limited citation provided, Ibato and others versus Barakuro and others citation captured. Defendants had consented to argument on record procedure and did not file any schedule to object to any of the documents relied on by the claimant. It is deemed that they do not object to any of the documents front-loaded by claimants. I so find and hold. Be that as it may, I've taken a look at the pictures front-loaded, and I can say for a fact that there is nothing in those pictures to show that their constituency projects carried out by some of the claimants as alleged. Those pictures could have been taken anywhere. There is nothing on those properties linking the claimants with the properties in the pictures to suggest that those are constituency projects which were carried out by some of the claimants. The pictures are those of no evidential value in this case, as they cannot prove that claimants intend to use them to prove. As they cannot prove what claimants intend to use them to prove. Claimants who wants the court to believe that they awarded contracts or credits to contractors who have carried out the projects and abandoned midway and are now making demands, have not placed before this court any credible document to show that a contract was awarded to any contractor to carry out any constituency project during the years in dispute. They could have opted for full trial and call any of those contractors who allegedly made oral demands as witness or subpoena any of the alleged contractors to prove that they actually carried out the constituency projects during the relevant period. Also, as rightly submitted by Learned Defense Counsel by paragraph 4.5 of his final address, the only demand letter pleaded and front-loaded at page 39 to 45 of the record purported to have been a letter of demand written by the contractor to the fourth claimant is in respect of a project awarded in April 2016. In fact, the letter of demand in its paragraph 3 clearly alluded to the copy of the award letter, which was attached thereto as an annexure to the demand letter, which Learned Defense Counsel wrongly construed as a separate independent document, which was not pleaded in paragraph 4.7 of his final address. The said letter of award at page 45 of the record is clearly an annexure to the letter of demand going by paragraph 3 of the letter of demand. The letter of award was written on the 10th of April 2016, and from the purported letter of demand, the project was carried out forthwith by the said contractor. Specifically, the heading of the letter states that the contract was executed 3rd of January 2017. Claimants in this case are not claiming for constituency allowance for the year 2016 or 2017. Neither did they say that the said allowance was not paid in those years. Rather, they are claiming constituency allowance for the year 2018 and 2019, which is clearly outside the reader of the project purportedly carried out in 2017, in respect of which the said demand letter was issued. Thus, the said letter is of no relevance in this case and of no value to the case of the claimants. In all, claimants have not proven their assertion that they carried out constituency project in 2018 and 2019 to entitle them to be reimbursed by the defendant for same. As reason supra, the allowance is not a personal emolument or personal entitlement of claimants as erstwhile legislators. It is for the benefit of the constituencies which they are representing, pursuant to section 117 of the Constitution. Service of the state or constituencies in their capacities as former elected legislators is an honor. The honor is denied from the selfless, the honor is derived from the selfless nature of the service of lawmaking. The purpose of the service of claimants as former lawmakers, and particularly constituency allowance, which they are claiming, in this case, is not to financially enrich themselves at the expense of their constituents whom they are representing. It is a fact of common knowledge, and one that has gained authority, that political office holders, especially lawmakers, get huge amounts of money as salaries and numerous allowances, some of which are not even justifiable while in office. Most of these lawmakers get paid these huge sums in the form of constituency allowances yearly, and have nothing to show for it in their respective constituencies. Most of them have taken the sum to be part of their numerous take-home largesse, failing to do anything for their constituency or constituencies who are supposed to be the beneficiaries of this bogus allowance paid to them. To them, it is an unaccountable free lunch that must be consumed at all costs at the detriment of the electorate who have reposed much trust in them. Thus, they fail or refuse to spend the constituency allowance to improve on the lot of their constituents. The fact that it's budgeted for does not mean that it is the right of every lawmaker, especially one who is no longer occupying the position as in this present, and has not been able to show that he carried out any constituency project during the relevant period, as in this instance. In my view, claimants have not established that they have a vested right over the constituency allowances, especially in this instance, that they are no longer members of the House. Assuming, but I'm not conceding that claimants were even intentionally denied the payment of constituency allowance, and same was based on political colorations as contended, the court cannot invoke the provision of section 42 of the Constitution, which was relied on by claimants' counsel in his final written address, to say they should at this stage be paid. The court has made solemn undisturbed finding supra that claimants did not acquire vested right or interest over the 2018 and 2019 constituency allowances, the subject matter of this action. In law, vested interest is, quote and unquote, personal interest or right in personal or right to derive or share benefit is protected by law or custom, unquote. See the case of Adesaoye and Adewale citation captured, in Dayako and Dantoro citation provided, Agbetoba and Lagos State Executive Council citation provided. Put differently, it is a right that has completely and definitely accrued to a person that is not subject to defeat or cancellation by an act of a private person or government, except by recognized procedure and for public welfare. This position is reinforced by the decision of the court in Lokoja and others, and Governor of Benin State and other supra, that it is useless invoking the provisions of section 42 of the Constitution, where a party has not established a vested right to the thing in question. It is in the light of all reason above that I refuse reliefs 1, 2, 3, and 4 in the originating process. Therefore, release 1, 2, 3, and 4 are dismissed.
I'll stop, please.
Please mute your phone. Claimants in this case are equally claiming that they are each entitled to the sum of 4.3 million naira, totaling the sum of 28.8 million naira severance benefits, which were not paid at the expiration of their tenure. Fact in support of this was pleaded in paragraph 25 of their statement of facts. The defendants, by their paragraph 27 of their statement of defense, avert that claimant claims above are denied and claimants are put to the strictest proof. Ordinarily in law, such averments are insufficient if traversed and are deemed an addition. See the case of Zenith Bank and KK citation captured, Mothercard Nigeria Limited and registered trustees of the Full Gospel Assembly Nigeria citation provided. I'm, however, mindful that claimants claim for the sum of 25.8 million naira as the total sum of their severance benefit of 4.3 million naira each is in the realm of special damages that must be strictly proved. Such special damages will not succeed on our admission because they are not to be inferred from the natural cause of things. See the Apex Court per Rose Vibor GSC, retired, in the case of NNPC and Clifco Nigeria Limited. I quote him, evidence ought to be led before an award for special damages is granted. To succeed in a claim for special damages must be claimed specifically and proved strictly. The fact that it appears to be admitted does not relieve the party claiming it of the requirement to prove with compelling evidence. Special damages are exceptional in character, and so there is no room for inference by the court. It is unreasonably to consider a claim for special damages reasonable in the absence of proof. A claim for special damages succeeds on compelling evidence justified, and not on the sums claim appearing reasonable to the court, unquote. See also the case of Capital Hotels PLC and others at Abdullahi citation captured, Arab Construction Limited and another, and Isaac citation provided. Thus, the basis that by the state of pleadings, the averment of claimants seem to have been admitted by the defendant does not relieve claimants of the burden to prove their entitlement to the sum claimed. Claimants must establish their entitlement to such special damages by adducing credible evidence. All that is required is that the claimant should establish their entitlement by credible evidence of such character as will satisfy the court that he is indeed entitled to the award under the head, or under that head. Claimant has reasoned supra validly within the context of legislators whom the Revenue, Mobilization, Allocation, and Fiscal Commission are empowered to recommend their remuneration or emoluments. Claimants who would want this court to believe that they are entitled to the sum of 4.3 million naira each as severance benefits have not placed before this court any remuneration, recommendation or guidelines issued by Revenue, Mobilization, Allocation, and Fiscal Commission, which entitles them to same as severance benefits. They have also not placed any instrument which grants same to them before this court. Noteworthy is the position of Learned Defense Counsel in paragraph 5.2 and 5.3 of final address, citing the case of Kogi State and others versus Ahmed Supra, which according to him, the court is bound by that decision to the effect that claimants are not entitled to severance allowance being political office holders. Let me say that Learned Counsel clearly misconstrued the purpose of the decision of Agim JCA, now GSC, in that case, which others concurred with. The decision of his lordship never said that a political office holder is not entitled to severance benefit. In fact, his lordship recognized the fact that most times this severance benefit provided to political office holders like president, vice president, governor, and deputy governor have constitutional backing, which makes them entitled. His lordship was only of the view that such provisions should not be contained in the constitution of a democratic country like Nigeria, that is marks of feudalism, thus it creates social injustice and does morally wrong. In fact, the salient part of that decision is captured here under those. I quote, I must state here, claimants claim for payment of severance allowance because the tenure of the appointment has come to an end is as unfounded as is morally wrong. As I've held, their letter of appointment did not stipulate their entitlement to such payment. They did not produce any law, any document or instrument that entitles them to such payment. It is not morally right to pay an elected public officer or political appointee pension and gratuity or severance allowance for holding such an office for 3 to 8 years, as the case may be. It cannot be justified in the context of our present social realities. It amounts to gross social injustice. The provision of section 84, 5 and 6 of the Constitution that provides that any person who has held the office of president, vice president shall be entitled to pension for life at a rate equivalent to the annual salary of the incumbent president or vice president if he was not removed from office by impeachment is not a moral law in the context of our governance experience since 1960. The same applies to section 124(5) of the Constitution, which enables the House of Assembly to make a law providing for the grant of pension and gratuity to a governor or deputy governor of the state who was not removed from office by impeachment. This kind of provisions should not be contained in the constitution of a moral society in which the primary objective of governance is the welfare and equal treatment of the people. The identifying character of a democratic constitution is that it vests the sovereignty of the country in the people of Nigeria, from whom all authority of government is derived and for whose welfare and security such authorities exercise. Such a constitution that promotes social justice and existence of an egalitarian society should not contain features of feudalism like the provision of pension and gratuity for all holders of the office of president, vice president, governor, and deputy governor of the state. The fact that the right is provided for in the Constitution and thereby made a constitutional right does not make it morally right. It is an absurdity in the democratic constitution, unquote. Learned Defense Counsel obviously cited the case out of context, submitting that the court in that case said an elected political officer is not entitled to severance allowance, and as such claimants are not entitled, and as such this court is bound by same. The point needs to be made that cases are authorities for what they decide. Those authorities ought not to be cited and or applied outside their factual context. See the case of Anja, Cora, and PDP citation captured. That was never the decision of the court. The decision of the court, as seen above, even recognized the entitlement of political office holders to severance benefits provided by law, but that such provisions should not be contained in the law in a democratic society, and that paying them such is morally wrong. The fact that something is morally wrong does not mean that it is unlawful. Even if His Lordship recognized the provision for such in the law, the decision in that case above was because claimants therein did not prove their entitlements by placing before the court the instrument that grants such to them. The decision of the noble jurist in that case was not on the legality but morality of severance allowance. Had the claimants in this case produce an instrument or recommendation of revenue mobilization, allocation, and fiscal commission entitling them to the amount claimed as severance benefit, they may have succeeded. The failure of the claimants to strictly prove their entitlements to the sum of 25.8 million naira claim as their joint severance allowances being special damages fatal to their case. It is in the light of the above that this court finds that really fine.
Kai, didn't hear the last part. It's not clear. We can't hear anything. Honestly speaking. Hi.
Okay, there's nothing wrong with your system. She's coming back.
We can't hear you. Has he finished with the judgment? So we can't hear him. I can't hear her again.
Okay, Stanley, wait.
Okay.
And then we proceed. As regards relief 6 for damages, I think I've cited the decisions. It is not granted or even contemplated, whereas in this instant case, the claimants have failed to establish the liability of defendants or
Can't get the judgment. I'm no longer hearing. Definitely. We are not hearing. It's still on. Register, we can't hear.
Just a minute, I'm here with you.
It's okay, my lord.
Can you hear me now?
Very well, my lord.
Very
You can hear
well.
my lord.
So I'm almost through with the judgment. I'll just read it quickly.
Ask up, please.
Not granted, or even that is talking about general damages. Relief 6. It is not granted or even contemplated, whereas in this instant case, the claimants have failed to establish the liability of defendants or their entitlements to the sum claimed. It is the law that ancillary or incidental accessory reliefs or claims are so inextricably tied to or bound up with the main relief or claims in the suit. And as such, where the main claim or reliefs fail, the ancillary reliefs the ancillary or incidental accessory or reliefs or claims will also fail. The failure of the claimants to prove the main declaratory relief sought means the ancillary reliefs of general damages has no basis because damages cannot be awarded in vacuum. See the case of McDonald's Scientific Emporium Limited and Access Bank citation captured. The case of Udu and others versus Ogudu and others citation provided. Odulaj and Wemo Bank and others citation captured. Accordingly, Relief 6 also fails. It is apparent from all the reasoning and holding of the court above that claimants have failed to prove their case. The position of the law is clear that whereas in the instant case, the claimants failed to prove their case for a declaration of entitlement to the sum claimed, the proper order to make is one of dismissal. See the case of Macan and Hagem and others citation captured. The notable case of NPA, PLC and Lotus Plastic Company Limited citation captured. The case of Uzochukwu and others versus Eri and others citation captured. Since claimants have failed to prove their case is therefore liable to be dismissed. Claimant case is hereby dismissed. Parties have to bear their respective costs. Judgment is accordingly entered.
Ascot, please.
Counsel would copies of the judgment to be forwarded to you in Lokoja.
Ascot, please. Ascot, please. We appreciate the court for the industry, which is the judgment. We are grateful.
Very well.
We are grateful, my lord.
Very well. For the other matters, just give me about 20 minutes to quickly charge this laptop for a while, okay?
Yes, my lord.
I'll be with you. Learned Counsel, I'll be with you in a short while. Thank you very much. I will rise for now. We will rise for now.
Subscribe.
This is the courtroom. Is Lokoja ready? Divisional Registrar. Can you hear me? Can you hear me? Divisional Registrar is no longer here. You can't hear. He's not online. Court Registrar. Adams project to let them know that I'm set. The lines are not going to send a text message. There's no 15 here.
So people can call out of turn, maybe Mr. John wants to call. I don't know. My case is number what?
You want to use this?
Which one? What?
But this one does not talk.
One.
Lokoja, can you hear me?
Yes, my lord.
Very well. Go ahead and call the case.
Case number 2, NICN LKJ 11/2021 between Nuche Musa Muhammad and Kogi State government and 3 others. Parties are absent, my lord.
Appearances.
Wait, please, my lord. FB Obayori.
Wow, I can hear you clearly.
Ascot places.
Your
Principal
designation.
legal officer. Principal legal officer.
Very well. Kogi
And I
MOJ.
appear with DM Okolo. Principal legal officer. We appear for the defendants.
No appearance for the claimants.
None in the
Nil
court, my
for the
lord.
claimants. None online.
Online.
He was online. I'm not saying him now. Since he has not connected.
The person was online.
Yes, Oboni, my lord.
What's the name of the lawyer?
Oboni. Austin Oboni.
Mr. Oboni. Are
Yes,
you the
ma'am.
one using Phoenix Hot? Mr. Oboni.
He's not online now, my lord.
Okay. Nil for the claimants.
Ascot places.
What's the business of the day?
My lord,
Did
the
you
case is
file
for...
a reply on point of law?
Yes, my
It's
lord. It's
for
for
adoption.
readoption, my lord.
Yes. Very well. Did you file any reply on point of law?
Yes, we did, my lord.
Go ahead and adopt your final address.
My lord, our final written address is dated 4th day of April, 2023.
And
And
filed
the same date, my lord, 4th day of April, 2023. My lord, on receipt of the claimant's final written address, we file a reply on point of law. It is dated 26th day of April, 2023.
and filed
And filed the same date, my lord.
the same date.
Yes, my lord. We humbly seek to adopt them, my lord, as our argument in support of our defense. Urging my lord to dismiss the case of the claimants.
Very well. So what do I do to the claimant's final address?
My lord, deem it adopted, my lord.
Very well. When did you file the final written address?
Sorry, my lord.
When did the claimant file his final written address? When did he file the final written address? 18th of April.
Don't worry. My lord, is dated 17th day of April. And filed 18th day of April.
Court registrar. Here, court registrar, Abuja, let me have the diary. Today is 17th. What day of the week? Lokoja, what day of the week is 17th of October? What day of the week?
17th.
October is on Tuesday.
Eh?
Tuesday, my lord.
Very well. Case adjourned to 17th of October 2023 for judgment.
As court places. Thank you.
Claimant final address is deemed adopted pursuant to Order 45 of the rules of this court.
As court places.
Call the next case.
Case number NICN LKJ 5M 2022 between Antonia Ojua Omeza and Kogi State Polytechnic and another. My lord, the judgment creditor is in court. Judgment data absent, my lord.
Well, we are sorry. Only one system is working in the whole of this court now. My lord, we are sorry. My W.A. Aliwo is my name. I'm appearing for the judgment creditor. With me,
what are your initials?
W.A. Aliwo. With me is Adejo A.A.
For the judgment
creditor, my lord.
With you
is Adejo A.A.
Very well.
Our appearance is for the judgment creditor, my lord.
Any other appearance?
May it please, my lord, FB Obayori. Principal Legal Officer.
Very well.
My lord, I appear with DM Okolo, Principal Legal Officer. Our appearance is for the judgment debtor applicant. Respondent.
My lord, the business of the day is for report of settlement.
Very well.
My lord, we have filed terms of settlement.
When did you file it?
Terms of settlement was filed on 15th of June, 2023.
What I have here,
Yes, my lord.
I don't have your, well, just a minute. Yes, you filed it on the 15th of June, 2023.
Yes, my lord.
So what do you want the court to do with it?
We humbly urge your lordship to adopt it as, we humbly adopt it and urge your lordship to order according to our agreement, my lord. It's a post-judgment and post-execution agreement. Post-execution
Very
settlement.
well.
Thank you, my lord.
About your reaspire.
My lord, we are in agreement with say, my lord.
Why is lordship not appearing? Okay. Feels like it's frozen. Huh? It's like it's frozen.
Very well. The terms of settlement executed as witnessed by counsel and filed by both parties, same having been adopted today, is entered as the ruling of the court as per the terms.
God please you.
Very well.
My lord,
Uh-huh.
in view of, in accordance with the order, my lord,
Mm-hmm.
I think the order for use of the judgment debt
Yes.
was an order of the court.
That it should be paid into the
chief registrar's account.
Okay. Okay. Consequently, just a minute.
Exactly, my lord.
Consequently, the judgment sum already paid by the judgment debtor to the to this court. V, the check issued in the name of the Chief Registrar of this court is to be released to the judgment creditor forthwith.
As called,
Let's go, please.
Divisional Registrar, Lokoja, are you online?
Is the register online?
So take necessary action in ensuring that the money is released to the judgment creditor.
My lord, I'm online, man.
Very well.
I'm
Ensure that
online, my lord.
yes, very well. Ensure that the money is released to the judgment creditor.
Let's go, please.
So what do you want to do with this motion that you filed again, Mr.
My lord,
Adi?
we are withdrawing it, my lord.
Very well.
We only apply to withdraw the motion that we filed in consequence of our agreement based on the order of this court. The motion which is
When did you file it?
the motion was filed on 23rd of June and it's number 19M 2023.
Any objection, Obayori Esquire?
well, no, we are not
Or is
objecting.
it ex parte?
No, it's not expected, my lord.
We are not objecting, my lord.
Okay. Motion filed by the judgment creditor on the 23rd of June 2023 is hereby struck out. Next case.
It's my head. Let's go.
Go ahead, next case.
Case number 4, NICN LKJ 07-2023 between Mr.
We can't hear you. Court registrar. Court registrar. Court registrar, Lokoja. Divisional registrar, can you hear me? Court registrar, we cannot hear you. Call the case again.
NICN LKJ 07-2023 between Mr. David and the Governing Council, Prince Abubakar University, Ayimba, 4 others. My lord, all the parties are absent.
This matter is coming up for the first time. Call the other 4 defendants. Call their name.
Okay. Between Mr. David Ekei and 1 Governing Council, Prince Abubakar University, Ayimba. 2, Prince Abubakar University, Ayimba. 3, Professor Meriatu Tenuche, Vice Chancellor, Abubakar University, Ayimba. 4, Anuhi Aminat Bosa, Prince Abubakar University, Ayimba. 5th, Nuhu Ahmed, Registrar / Secretary of the Council, Prince Abubakar University, and all the parties are.
Appearances.
Respectfully, my lord, sir. I'm EA Major. My lord, I hold the brief of Agoli.
For the
Hold the brief of
AS Agoli.
For the
claimant.
Any other appearance?
Yes, my lord. My lord, I am OU
Omale.
Esquire. I humbly announce the appearance for the first, second, third.
Are you from the Ministry of Justice?
Yes, my lord.
Your designation?
I am a legal officer.
Senior legal officer.
Chief
legal officer.
Yes. I announce my appearance of all the defendants applicants.
Very well. You have an application before the court?
Yes, my lord.
When was it filed?
Yes, my lord. It was filed on June 2023. And it's dated 13th day of June 2023.
It was filed when?
It was filed on June 2023.
The motion?
Yes, my lord. Together with all the
Mr. Major B, are you in receipt of the motion?
Yes, my lord.
Any objection?
No objection, my lord.
Move in terms.
I hereby
Yes, my lord, we are in receipt of the motion. We have no objection to it, sir.
I hereby move in terms of motion paper.
Very well.
Thank you.
Order is as prayed.
I stop.
My lord, sir.
We
have a motion which is filed on the 9th day of May 2023.
For summary judgment.
Very well, my lord, sir.
And are you sure that by the defense before the court, that's
yes, sir. Very well, my lord. That's why we want to withdraw the motion.
Okay.
And we seek to withdraw the motion of the claimant on the 9th day of May 2023.
Any objection, Mr. Major Omale?
No, my lord, I have no objection to their withdrawal.
No, I have no objection to their withdrawal.
The motion filed by the claimants on the 9th of May 2023 is hereby struck out.
As court basis.
Any other thing?
Does the report.
How about the one you filed asking the, okay, it's the same. Do you want to file any reply to the defense filed by the defendant?
My lord, sir, we intend to file a reply to the joint statement of defense, my lord.
The claimant is at liberty to file a reply to the defense.
As copies.
As copies, my lord.
Within 7 days, and serve an advance copy on the defendant.
As copies.
So you file your reply and the further statement on oath.
As copies, my lord.
So what date for definite hearing? Court registrar.
15th November, my lord.
What date?
15th November, my lord.
Counsel, can you both agree to 2 dates for commencement and conclusion of trial?
15th, 16th.
Are the 2 dates convenient?
As copies, my lord.
No.
15th and 16th, is it October or November?
November, my lord.
Oh, no.
By agreement of counsel, case adjourned to 15th and 16th November 2023 for definite commencement and conclusion of trial.
As copies. Most good.
For the next case.
Case number 4, NICN LKJ 04-2023 between Suleiman Dadao and 1 Kogi State Polytechnic, 2 Kogi State Government. Claimant is in court, my lord. Defendant absent.
Appearances.
Respectfully, my lord.
Please unmute your system. Go ahead. Go ahead and announce your appearance.
Announcer.
My lord, the other counsel is trying to announce his appearance.
Okay, let him do so. Is claimant counsel in court?
Okay, may it please, Honorable Court. I am Abdul Malik Bello.
Where is your counsel?
Abdul Malik Bello.
My representation is for the claimant respondent.
For the claimant
respondent. Judgment credit from my lord. Although designated as claimant respondent, but judgment credit of respondent.
Any other appearance?
Respectfully, my lord, sir. My lord, E.A. Mejabi. E.A. Mejabi and N.A. Abubakar
Appears for the defendant's
defendant's
applicant.
applicant.
What do you have before the court?
We filed
Go
a
ahead.
motion, my lord, sir, on the 11th day of April.
On the 11th of April.
Very well, my lord, sir. I hope the claimant respondent have a motion.
Mr. Malik, Mr. Bello. Mr. Bello. Mr. Bello, are you online?
Yes, my lord.
Okay.
Yes, my
Are
lord.
you in receipt of the application filed by the...
Yes, I am. Can you hear me, my lord?
Yes, please. So have you reacted to it?
Yes, we filed our counter affidavit.
When did you file it?
It's dated the 7th day of July, 2023.
Seeking for extension of time.
7th day of July. No, the application seeking for extension of time is, sorry, my lord, is dated the 3rd day of July, 2023. And then the counter affidavit proper is filed on the 7th day of July, 2023.
I've asked a question. You filed a motion to regularize the counter affidavit, right?
Yes, my lord.
Together with the counter affidavit.
Yes, my lord.
Asking for a deeming order.
Yes, my lord.
That application has not been moved.
Yes, it has not been moved, my lord.
Go ahead and move it now.
As my lord pleases. My lord, before this honorable court is an application dated the 3rd day of July, 2023. It's an application brought pursuant to section 36 sub 1 of the Constitution.
Just a minute, Mr. Mejabi. Do you have
Yes,
any
my lord.
objection to the motion?
I don't
Regularize?
have an objection to the motion.
Very well. So move in terms of that motion, Mr. Bello.
My lord, we hereby seek to move in terms. While urging my lord to grant our application.
Order is as prayed.
As the court pleases. Thank you so much for the consideration, my lord.
So the cost is clear. Mr. Mejabi, do you have any, do you intend to file a reply to the counter affidavit or to file a fourth affidavit?
Very well, ma'am.
Hello? Nene Counsel.
Very well, my lord, sir. We intend to file a reply to the counter, sir.
No, not yet.
Are you sure you cannot resolve this issue? That's why I'm looking at the Mr. Mejabi.
Yes, my lord.
Why haven't you complied with the decision of the court?
My lord, sir, with respect to the court, sir, I'm aware that the principal in office had a discussion on this subject with the counsel to the claimant.
Okay.
And I'm sure that the resolution, if I wouldn't want to divulge too much information, but I was reliably informed that even the matter is before the Attorney General, who has recommended that they should comply with the order of court, and that was the process at that time, as I was reliably informed by them who had who is the counsel, my principal. But we were surprised when after the whole communication, we saw that they came back to court, even though they were properly briefed. MS Inua is in the picture. They turned around to...
And possibly because they have waited on ending and the government is not acting on the agreement. So you have to, I'm enjoining you to ensure that that is done before the next adjourned date, failing which you can file your reply and the court will take the application.
As God wishes, my lord, we are very grateful, sir. We'll take the message back to the...
Sorry.
Thank you, my lord.
Sorry, my lord.
Mr. Bello.
Sorry, my lord. I dropped out for a while due to network problems.
Okay.
So I really didn't get the point, but I met him at the very tail of his point.
He said that the Office of the Attorney General is trying to ensure that the judgment of the court is complied with. And so the court then encouraged him to ensure that that is done before the next adjourned date, failing which the court will proceed with the application.
Thank you so much, my lord.
Are you aware that there are steps being taken to ensure that the judgment is being enforced or complied with?
Yes, my lord, especially recently.
Okay.
So we intend to wait and see how that goes, and we hope it will all go well. And we just hope to return back to inform the court that we've settled and then to file our terms of settlement. Thank you so much, my lord.
Very well. Mr. Mejabi.
Yes, my lord.
The ball is in your court.
As court pleases. May we seek for another date, sir? The name Rose.
What date, court registrar?
16th November.
16. November 16.
Yeah. 16th of November.
It's convenient, my lord. November.
For either report of settlement or definite hearing of application.
Yes, my lord.
Call the next case.
Case number 6, NICN LKJ 04/2022 between Simeon Achenyo Joshua and 3 others, and Kogi State Government and 2 others. My Lord, all the parties are absent.
Just calm down. Bring it down.
Who is in court?
All the parties are absent, my Lord.
Parties absent.
Yes.
Appearances.
May it please me, Lord. I am Lokoja, appearing for the claimant.
Any other appearance?
May it please your Lordship. My name is Oluwafemi O Adegboyega, State Legal Advisor.
Just a minute.
As a person. My Lord, I appear with my learned friend.
You are for who first? For the defendant?
My Lord, I'm for the defendants, my Lord.
Then appearing with
Victor Shaibu, is a legal officer.
Where is Mr. Shaibu?
My Lord is in the courtroom. I don't know why.
I need to see him. Court register. Is one legal officer, Victor Shaibu, in the courtroom?
Shaibu in the court.
If you are, that is you.
Very well.
My Lord, we appear for the defendant in this matter.
So are you ready? The matter is for defense.
My Lord, the matter is for defense. However, my Lord, we have a motion to regularize the filing of our statement of defense.
Mr. Onoja, are you in receipt of their motion to regularize?
Yes, I just got the motion.
Any objection?
If I'm not objecting, but the order must be properly stated. We have finished our evidence before they are bringing this application. So if this application is allowed, it therefore means we are going to call our witness to enter into the witness box again.
Is that an application? Because your witness has been
Has been cross-examined, yes,
and he has been discharged. He has closed his case.
Yes, yes.
So
and now they are bringing an application.
Do you want to recall your witness? Then you have to bring an
application.
It's not an application.
You have to bring an application to do that.
No, Lord, we are filing response to their statement of defense.
Have you filed or you want to file?
Response to their statement.
Well, let me get you
they
right.
They are not even allowed to file their defense. What we are saying is that they have an application. Yes, my Lord.
Listen.
What we are saying.
Listen. There is an application to regularize their defense.
To bring in their defense.
Do you have any objection to this application to bring in their defense? If I may use your language.
Yes. Well, I'm not objecting to them bringing in their defense because they are entitled to defend the case.
Very well.
But
So
we are saying that
move in terms of the application.
As the court pleases. My Lord, the application is dated the 14th day of July 2023 and filed on the same date, my Lord. My Lord, I praise your Lordship for an order.
Move in terms.
My Lord, I move in terms of the application and I pray that your Lordship grants the prayers on the face of the motion paper as sought. We are most grateful, my Lord.
Father has prayed. The claimant is at liberty
to file a reply.
To file a reply to the defense.
As copies, that's what we are saying.
So when do you want to do that? It means you have to agree to another date.
Yes, my Lord.
What date?
Lucy, give us date.
Agree to a date.
November. 15, my Lord.
Is it convenient for both parties?
Yes,
15th of November.
15th, 15th. It's convenient, my Lord. Thank you.
It's convenient for me too.
Mr. Onoja, in filing your reply, if you want to recall your witness, in view of the further witness statement you may have to file, you need to put that in the application. You may have to file asking the court to allow you to recall your witness. Is that right?
My Lord, the coming to the witness box is as a result of the consequential filing of a statement of defense. I mean, reply to statement of defense.
Mr. Onoja,
But
you
you
like
still need to make the application. You need to make an application.
You have to apply because your witness has been discharged. Claimant has closed his case, but you have a right to reply because they didn't file within time. And that's why they brought an application for extension of time. They have done that. The court has given you liberty to file, but in doing that, in order for you to recall your witness, you have to apply formally.
As court places.
Very well. Call the next case.
Most grateful.
I'm most grateful, man.
Call the next case.
Case number 7, NICN LKJ 06-2022 between Honorable Fonsho Emmanuel Olorufemi and 5 others, and 1 Kababunu Local Government, 2 Ministry of Local Government and Chieftaincy Affairs. All the parties are absent, my Lord.
Appearances.
My Lord, the
Counsel.
claimant counsel sent a letter asking for adjournment that he's attending a national conference of Nigerian Bar Association.
Very well. How about the defense counsel?
He is not in court, my Lord.
Very well.
He was here earlier. He said he will connect online, Then didn't see him.
So give me a date. Is there anyone representing the defendant in court? Is there
No, my
anyone
lord.
Very well. So give me another date.
16th November, my lord.
Did the claimant suggest any date?
My lord, he gave a 27th of this month, but I informed them that we are not sitting on the 27th. So he will likely get a date in November.
Very well. Case adjourned to 16 November 2023 for definite hearing. Hearing notices to be served on the parties proved to be filed.
As the court pleases.
Any other matter?
One more, my lord.
Good.
Case number 8. NICN LKJ 01-2021. Sorry, my lord, 2023. Between Okpetu Idi Emmanuel and 8 others, and Kogi State University Anyemba and 3 others. All the parties are absent, my lord.
Appearances. Counsel.
With utmost humility to this noble court, O.U. Omale is my name. O.U. Omale, Chief Legal Officer. O.U.
Omale.
As court pleases. Chief
Legal
Legal Officer.
Oh, CLO.
Yes.
Kogi Ministry of Justice.
Announce my appearance for the first defendant.
Any other appearance?
Respectfully, my lord, sir.
EA
Major B and NA appear for the second to fourth. My lord, sir. I'm aware that the claimants counsel they were in court this morning.
Yes, please.
They were in court, and it was just when
Counsel, I cannot hear you. Unmute yourself and make sure you place the system before you.
And he left and promised to connect.
Mr. Major B. You said
Yes,
the claimant counsel did what?
I said he was in court this morning.
Okay.
But left after other matters for technical issue. I'm coming to join the office. But my lord, in Lokoja at the moment, all other networks are down, excluding Airtel network.
Oh, okay. So he may have been having problems connecting.
Yes, I hope so.
So it means you have to take another date.
That's why I don't know what the issue is, but he was in court earlier today.
Take another date.
As court pleases, my lord.
Have you all filed your respective processes?
Yes, my lord.
Okay.
14th November, my lord.
Of November.
Yes, my lord. 14th November.
So, my name, Mr. Major, is it convenient?
Very well, my lord. It's convenient. Also communicate the dates to the.
Very well. It is in view of the absence of the claimant counsel that this case is adjourned to 14/11/2023 for definite hearing. Counsel, the second and fourth defendant, Mr. Major B, is to communicate the date to the claimant's counsel.
At court, please. We are grateful, my lord.
Very well. Is that all?
That is all for today, my lord.
Very well. So the court will rise now from Lokoja.
November, ba? Your matter Idigbe to Emmanuel and others against KSU and others are adjourned to 14/11 for definite hearing due to your absence.